did you consider them? You were obviously aware of them. Did you rely on them? And it was quite clear that those statements by the defendant indicated quite a bit of planning before the homicide. And so, as part of the cross-examination, Bloom able to use those statements by the defendant to undermine the opinion that the defendant had not been able to plan the murders that happened. Let's go one step beyond the situation that's more often true. Boom, the testifying expert had noted in the testifying expert's report that these statements existed. Let's go a step beyond that. Suppose we have just a run-of-the-mill traffic accident case with serious injury. Plaintiff calls an accident reconstruction expert, and the accident reconstruction expert says that based on their examination of the scene, et cetera, the defendant was speeding at some exotic rate of speed. The defense is aware that at a deposition, some independent witness had testified, or perhaps not in the deposition, perhaps this was in a police statement. This independent witness had said that just before the accident, they saw the defendant's car, and the defendant seemed to be going about the normal rate of speed. On cross-examination of the expert, made the defense attorney ask the following question. So let me rephrase it more constantly. The defense attorney may ask the following questions. Remember, unlike Bloom, the testifying expert did not include these statements in the expert's report. The opposing counsel can ask the expert, did the attorney who hired him, a plaintiff's attorney, provide you with witness statements from the police report and depositions? The answer is yes. Then that can be followed up with, and did that include statements made by the independent witness? We'll call that person I.W. And if the answer to that is yes, then can be asked, so you read that statement? And if the answer is yes, did you consider that statement? And if the answer is yes, did you rely on that statement? And if yes, how do you reconcile that with your conclusion that the defendant was going 85 miles an hour? The point here is not only that with all those right answers, yes, 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 you can impeach, but if the answer is ever no, that can be even better for you. Imagine, did the plaintiff's counsel, before asking for you to analyze the case and issue an opinion on the speed, give you statements from the police report and depositions? No. Oh, well, that's interesting. Or if the answer is yes, did you read them? No. Or if yes, did you consider them? No. As you see, the yes questions lead to you getting the expert in a nice box can. And the effect is even more devastating if at some point along the line they say no. So Bloom provides a guideline for all of us, for you in particular, as to how you can get statements by other witnesses inconsistent with the expert opinion in to undermine that expert opinion.
Justice, I was thinking when we were talking about the yeses and no's, at one point in the no's, you could say, well then, let me prove the hypothetical to you. Let's assume there was a witness at the corner who was a member of the clergy and high standing in the community who said, oh, that car was driving slow, would that change your opinion? I think that's what I'm getting at.
Yeah, I think that that's right. I think that that's right.
Well, as long as you have something to back up the hypothetical, whatever, I'll make an offer of proof.
Exactly. And I would suggest leaving that till the end, and then if there's ever a no answer, then you can absolutely do that. Now, some of you, probably all of you, have a question in your mind, well, isn't there a hearsay problem? And all of you are thinking, doesn't the Sanchez case rear its ugly head? Well, I think every time we go speak, people say, don't talk about Sanchez. Everybody knows about Sanchez. We're sick about hearing about Sanchez. I'm not going to tell you about Sanchez. The bottom line is, it's not hearsay. You are not trying to introduce this for the truth of the matter. You are introducing it to impeach the expert witness, right? By showing the expert witness was not diligent, didn't do their job, is biased, because they're ignoring what should be an interesting okay? I get one good. All right, let's move away from, so that's 721A allows very, very broad cross-examination, and Bloom gives us that extra tool. Let's look at 721B. Well, we can look at 721B because it's logical. So I'll tell you about 721B allows cross-examination. Oh, back then. Here we go. Great, thank you. This is cross-examining the expert on on what we call professional or scientific texts, like Bloom with a variation. You have an expert, let's say it's our same accident reconstruction expert, and the accident reconstruction expert, in order to support the expert's opinion on the speed that the car was going, dependent speed, relies on the traditional speed derived from skid analysis. There's a formula where you plug in the length of the skid, and then you apply the formula, and that produces a pretty well accepted estimation on the speed the car was going after the goods were applied. So you want to cross-examine the expert because you're aware of a text on the art/science of accident reconstruction, where Professor, I'm the brightest guy in the world, has noted that there is some discontent among accident reconstruction experts on deriving speed from skid. Now, by the way, this is hypothetical. I am not aware of any, in fact, dissatisfaction with that formula. But for the right price, I'm sure you can find a couple of people who are. Now, what you want to be able to do is cross it. You don't want to bring in, Professor, I know more than anyone else on the subject. You want to cross-examine this expert on statements in the text written by the non-clinical expert. And the question is, when can you do that? Under 721B, whoops, can we go back to the last? Oh. Is there? No. Okay. So 721B says you may not cross-examine an expert on a scientific technical text unless the testifying expert referred to that text, or considered it, or relied on it. There's those same three words as made up the bulk of those questions we were asking the expert in my variation of blue. So, that may not help you. But you can do it if the text or portion of the text has already been imputed into evidence. Well, that could be unlikely. Or 3, you have established as a reliable authority. And by saying you've done it, that means you've had either the testifying expert agrees that it's a reliable authority, or you have called an expert who says it's a reliable authority, or through the court taking judicial notice. If you do that, then you fit under the second case, Page versus Safeway. And in Page versus Safeway, the plaintiff had slipped and fallen at a Safeway, in a Safeway parking lot, not long after the store had relined that parking lot and covered it with some material. And the Safeway expert testified that the material used post-relining was absolutely the right material in order to make sure it was slip-proof. It was the best material we could use, so people would not slip on it when it got wet. The defendants wanted to cross-examine Safeway's expert. I say the defense and the plaintiff wanted to cross-examine Safeway's expert by quoting from the American Society of Testing Materials. I have to read this. I'm phrasing the words off my tongue. The American Society of Testing Materials standards relating to safe walking materials. Who knew there was a book on safe walking materials?
Those are books we have in this case.
There you go.
The acronym is ASTM, and I had to look up what it stood for.
The beauty of my job is I sit back and I who knew this stuff was going on? And then the beauty of Don's job is that knowing that I know so little, he can every once in a while try to make something up. And who am I to say no? But then I rely on you to say, wait a second. Oh. Point is, in a very different context, but just like the lawyer in the Bloom case, you're going to be able to bring in this testimony to impeach, not for the truth of the matter, but why didn't the expert read this book? And you may well be able to get that expert to admit that that is in fact a reliable authority. The trial court page was made in Roman's room. It's quite clear from 721B that even if the testifying expert did not reconsider and rely on the out-of-court text, if it's established as a reliable authority, you may introduce it under 720. Okay, well, all right. That's what I have to say about, yes. You're Ashley, you sat at breakfast table.
Yes, I did.
No, I hadn't. If I had known you were going to ask me a lot of questions, I would have been much more polite to you.
You indicated that it would be a possibility of getting that expert while you're cross-examining them to agree that it is a reliable text. Is there any kind of limit on being allowed to bring it up on cross-examination as potentially getting agreed to? I can see bringing up a text and having it objected to because it isn't already recognized, even though you're in the process of trying to do so.
Oh, typically the judge will be understanding if you're asking what I might think should be question 2, and you're asking it first. But I would say it's better to ask question 1 before question 2. But in this case, it seems to me perfectly sensible to say, now, Mr. Testifying Expert, are you familiar with Professor so-and-so's text on slippery materials? And if they say no, that's fine. If they say yes, then you can say, and is it in your industry considered a reliable report? And by the way, you may be sitting there thinking, oh, some guy will say no, it's not a reliable report. That doesn't always work out well. I mean, if the questioner, the cross-examiner, has somebody who come in, you don't have Professor so-and-so come in, but your expert's going to say, yes, this is very well recognized. The American Society of Testing Materials, it's like, I don't know, the Supreme Court of slippery surfaces. So that's all.
Thank you.
The one thing I was going to add about page is that the court goes through an extensive analysis of this, and I think it's absolutely right. But then at the end it says, well, but it's harmless error, it didn't affect the result. So it's a question whether how much good this does. That's the kind of thing that usually happens in criminal cases like People versus Bloom. They go on and on and on. All these great evidentiary points that say guilty as sin, guilty as we're not guilty.
May you sin on that.
You're the same in prison. Klein versus Zimmer is another case about experts. And in some ways, it isn't really even an evidence code case. It is now, but it wasn't at the time. What am I talking about? Well, so there is a rule, of course, in personal injury cases, if there's a claim that something has been caused, and the medical expert testifying has to testify to a reasonable medical probability that was the problem. That's what the plaintiff does. In Klein versus Zimmer, a unfun medical device case, the plaintiff managed to convince the trial court to exclude the defense medical expert because the defense medical expert didn't say any of these other causes were the cause to a reasonable medical probability. He just said there's this other stuff that it could have been. It wasn't necessarily the defective hip joint or something else. Excluded. That's the trial court level. On appeal, court appeal says no. It's error to exclude that defense medical expert. It doesn't have to meet the same standard as the plaintiff's medical expert. Why is that? Because it's the plaintiff's burden of proof to show that the injury was caused by this. It's not the defense's burden of proof to say it's anything else. It's only the defense's job to say, to cast doubt on that in any way possible, which could include just if there are other possible causes, it could have been this, it could have been that. They don't say that any one of those other possible causes was the cause to a reasonable medical probability. A totally reasonable international decision that, like so many, vote on maelstrom of response to the legislature. And folks on the plaintiff's bar side said this is not fair, and it ought to be even. Ought to be evened up on both sides. They should have to do the same thing. So now it is an evidence code issue, but now there's this new evidence code section that said where the party bearing the burden of proof has that burden, then the expert for the defense has to testify to the same high level of reasonable medical probability. And this is one of the other great things about legislation. And then there's subdivision B. But it doesn't have to be that if the defense wants to say that a matter can't meet the standard for reasonable medical probability. So, if there's 4 possible causes, I can't say that any one of them is 51%. This says the defense expert gets to testify to that. That was not, I think, the intention of the original drafters of this. Again, as I said, they were trying to say that no, this should be a quote-unquote even playing field. Again, probably more a matter of really a substantive law than an evidence law, but now we have an evidence code section, and we'll see what happens with that evidence code section next year.
Don, before you go away from that, it almost seems like subdivision B is just what cross-examination used to be for, right? The defense expert doesn't bear any burden of reasonable medical probability, and just poke holes in all kinds of things.
But remember, this isn't cross-examination, this is direct examination. Yeah.
But then up here, maybe that actually applies if your defense expert is trying to prove some other exclusive cause.
Oh, it definitely does. If it's just cause A versus cause
Right.
B, then I think you're there.
Or it might just be legislative charge and redundancy. So I guess we'll see.
So our next case is people versus entail. And in this case, well, I'm only going to talk about the hearsay issue.
What about it?
50 issues. Okay, so I'm going to talk about the hearsay issues in this case. So defendant was convicted of a number of things and he was sentenced to death. The backstory to this case is actually quite complicated. There were a bunch of individuals involved, but to mostly simplify, essentially there's defendant, there's another defendant, Carrillo, and they both accuse each other of being the shooter in the case. So there were 2 victims. There was a non-surviving victim, and then there was a victim that survived. So the first hearsay statement was from an eyewitness who saw the shooting. So town eyewitness described the shooter as a thin built. At the time, defendant weighed over 300 pounds, whereas the Carrillo weighed about 160 pounds. So it would be consistent with defendant's story that was Carrillo shooting. So town couldn't be located during the trial. Defense tried to admit his testimony as a spontaneous statement. So the factors that are considered for a spontaneous statement are passage of time, whether it's blurted out or made in response to questioning, emotional and physical condition at the time, and also whether the content of the testimony suggests that there is opportunity for reflection. We're looking at the facts of the case, that it took a while for the police to show up to the scene, about 5 to 10 minutes. Then the police spent some time talking to another officer at the scene. Then he talked to the other eyewitness before he finally talked to town. Well, that was sufficient to find that he was willing to qualify as a spontaneous statement. The Supreme Court also noted that it's rare for answers to extensive questioning by police to qualify as spontaneous statements. So the next statement was from the other defendant, Carrillo, to his sister-in-law while they were apparently on the same jail bus. So she had asked Carrillo whether he killed Johnson, who was a non-survivor. And apparently Carrillo responded, well, everything points to T-strong and that he was going to run with it. So the Supreme Court found that the trial court did not abuse discretion in excluding this because it's a little bit ambiguous whether it's actually inconsistent with the statement. So at trial, obviously, Carrillo said it was defended. And these statements don't necessarily contradict it. And because it's a little bit ambiguous, the relevance is decreased and there's also an enhanced risk of misleading the jury. So under Section 352, it could be proper to exclude as well as per the issue test. And then our last statement is a statement from Perdón. So she's the girlfriend of the surviving. So Mascoya actually was the one who survived. And apparently, at one point, the defendant had told Perdone that he basically bragged about killing Johnson. But then at trial, Perdone, in response to questioning, consistently said, I don't remember whether the defendant talked about that shooting. And so the trial court did permit Mansukhani to testify about what he had heard from his girlfriend earlier on. And it was admitted as a prior inconsistent statement. And so for a prior inconsistent statement to come in, it must actually be inconsistent with the trial testimony. And if the trial testimony is, I don't remember, then there must also be a reasonable basis that those I don't remembers are releasing untrue. And so there are some facts of the case that suggest that she was releasing. So she's friends with his brothers, and she was called to detail other facts around the same time.
So that
No, so it came in. So the surviving victim, Mansukhani, was able to testify that essentially his girlfriend was changing.
Were those facts like that the testimony beforehand, or how did you yeah.
You mean, so I think at trial she was testifying, and then when she was saying things that was inconsistent.
Yes, they asked her questions, and prove that she's being evasive, or how did they do that?
I believe the prosecution wanted to present Mansukhani as to offer testimony that would be inconsistent with what But honestly, the case is 50 pages, so I don't exactly remember.
Well, I think the standard way you would prove it typically would be there are witness statements, there are other there are police reports, there are various things that make up the body of evidence in the case. And the prosecutor and the defense attorneys are aware of these things. And it could be prior statements by this witness that are on record or could be introduced on the record for the purposes of impeachment, for example. And that may be the context in which the apple gets compared to the orange in terms of what she's testifying. Now, there's going to have to be a basis for it, I believe, but there's probably going to be in the record.
Two thoughts. What often happens, at least in criminal cases, where the I don't remember is challenged as evasive, and if the court agrees, you can then introduce the inconsistent statement, is that the witness tends to remember a lot of things about what happened, and then at some critical juncture just doesn't remember that. And doesn't remember telling a police officer about that. So that becomes a pretty good indicator. One thing I generally want to mention, at the very start I asked how many people are civil, criminal, specialized civil stuff. It used to be that civil practitioners wouldn't read criminal cases, and criminal practitioners wouldn't read civil cases. Well, certainly that makes sense if you're talking about the substance, elements of some crime or some form of civil liability. But if you're talking about evidence, it's only one evidence code. And it is often true that criminal cases are far more prevalent in the published opinion than any particular segment of civil cases are. And those cases are very common in the evidence code, and you're going to have to know them and how they apply. Even if you're a family law or probate court, they apply in those areas too. And I've certainly heard people resist that concept, but it's true.
And yesterday, I had an associate in my firm ask me why I suggested we feature a people versus case in a column about evidence issues. And she actually asked me, why are we using this? And I essentially said something along the lines that Justice Simons just said, which is if you want to stay abreast of the development of the evidence code, look at when the advance sheets come out or when you get the reporter email with today's announced cases, Don't just look for the cases that are like Section 998 or some other thing that's important to your case, Code of Civil Procedure, whatever. Watch the people versus case and just quickly scan to see what the evidence issue is. But that's your stock and trade. And those of you who are in court all the time, of course, know this, but maybe some of you don't focus on those cases.
I'm really proud that both of you can say that without mentioning Sanchez.
Well, I was just going to do it just now because when Sanchez came out, it basically blindsided not only trial lawyers up in that state, but judges too. And it caused a lot of upheaval, as I'm sure you all remember. And for some of you, it's triggering that we even mention Sanchez. So we'll move on. But I'm going to talk about People versus Portillo now, which is a court of appeal decision involving hearsay. And so the issue in Portillo was the value, the fair market value of several boxes of dumbbells.
There were dumbbells galore in Portillo.
There were dumbbells galore. And he's referring to the weights, and possibly the defendants, but not the judges. And he may be including me, because every time I read this case and think about it, I wonder if I'm the dumbbell. But there were 15 boxes, and the critical issue was $950 value, because that was the difference between a felony, grand theft, an element of grand theft, $950. That was the line. And of course, the defendants didn't want to be convicted for grand theft. And so what happened there was the theft took place at a warehouse. And after it happened, the warehouse manager, apparently the warehouse was just the middle person. They weren't making them, they were just shipping them, and they lost them when they were stolen. So he didn't have any specific information on the value of one box of dumbbells times 15. So he did what most of us do when we're curious about something cost, which is he went online. And he saw on Amazon and Walmart and a couple other places, there were prices advertised per box. And the lowest was a price of $357 per box. And obviously 357 times 15 got the prosecution to over $950, the element of grand theft. But the issue on appeal, defendant argued that this was hearsay, that the testimony about the price of the box shouldn't have come in. And what makes this case interesting to me, and what makes a hearsay rule sort of antagonizing to me at least, is that we often can see why a result is reached, but we also see that the courts don't always agree on the reason. And that could be a little frustrating if you're somewhat, I don't know, if your approach to hearsay is like mine and you tend to struggle with its exceptions and so on. And so what happened there is two justices of the Court of Appeal said the observed price of $357 was not the actual price, and it wasn't being offered, therefore, as the truth of what the actual price was, but rather because circumstantial evidence is permissible to prove fair market value. The California Supreme Court has said that before in a case called People versus Brand. This was just an invitation to transact. It was an invitation to transact. So it was circumstantial evidence of the potential fair market value of the dumbbells as not the actual price being $357, but as an invitation to transact. So it could come in. Two of them found that, and grand theft sticks as a charge. The defendant loses the appeal. But I just thought to myself, like, okay, when is the last time you walked into Walmart and saw the box of something at $357 and said, hey, I'll give you $200 for that, right? And what did they say? Who does that, right? An invitation to transact. Now maybe I'm missing something. I should have been doing that all these years. And I paid a whole lot of money for stuff that I could have bargained. But anyway, that's what the majority says, is it's not offered for the truth that it's $357, but it's circumstantial evidence based on an invitation to transact. Now, the concurrence gets to the same place. This is a single judge of the three on the Court of Appeal. And he wants to say, no, it's the price. The price is the price. It's $3.57, and that's the price. But it's not offered for the truth because these prices, when you see them on the sticker, when you see them in a window, when you see them online, they have a legal effect in and of themselves. They are verbal acts or operative facts as viewed within the evidence code, which carry the consequence of you being able to say, give me that for $357 a box. I want it, I'll pay it. So he says that this is still circumstantial evidence. It's not offered for the truth that you'll walk out of the store having paid only $357, but it comes in as non-hearsay because it's a verbal act or an operative fact. And reading the concurrence, very thoughtful, and reading the majority, very thoughtful, quite an exposition on hearsay, I'm like just WTF, right? I'm like, okay, which is it here? And I say all that because what comes to mind for me is a California Supreme Court case called Hart versus Keenum. And in Hart versus Keenum, the issue was there was a logo on an invoice observed by a person's eyeball as a witness. And the Supreme Court said that logo, a distinctive K, observed with the eye, just like a price tag is observed with the eye, was circumstantial evidence that Keenum manufactured the pipes in question that were delivered to the job site. And what it did not do is bend itself in circles trying to say that it was an invitation or something about Keenan pipes or possible something about Keenan pipes. And it also didn't say something like it's an operative fact or it's a verbal act. It just said, subject to the usual cross-examination for reliability, this is merely circumstantial evidence of Keenan's logo. It might have been there, the pipes might have been there, and it can be connected with other evidence. Well, I get that in People versus Portillo. You don't have that other evidence. You just have 3 different prices observed at 3 different websites. So maybe you need something more. But what I come away from with this is that we can never stop wrestling with the hearsay rule and its exceptions, because if people who struggle like me can't figure it out, we look to the courts. And the courts don't always come up with the same answer, even at the Court of Appeal where they get a lot of time to think about it. So that's my take on People versus Portillo.
The only thing I would add, and it's implicit in what Gary said, is the 3 justices who decided Portillo, each one of them is really top-notch. And the effort they put in, you can tell from reading the 2 opinions, a lot of effort. And I've gone back and read Portillo several times. I read an article Gary wrote on Portillo, an article by a 4th Court of Appeal judge from LA who wrote a Daily Journal article on it. And it gives me a headache. I like wrestling with evidence. I like figuring out, trying to figure out all these nuances. But I'll tell you, it's tough.
Gary talked about this as a matter of all the exceptions, but you can look at it a different way. This doesn't even get to the exceptions. This goes straight to the hearsay rule. The hearsay rule doesn't make all hearsay admissible. It's inadmissible if it's offered to prove the truth of the matter asserted. Irving Younger once said, if you can't come up with another purpose for this evidence, you're not a sophisticated argumentative lawyer. And I think this case is an excellent example of why. Why? Because it says, oh, it's not offered for the truth that Walmart would sell this for this amount, which we all know is totally true. That's why they put price tags on it. No, instead it's offered for the truth of something else. For the truth of what the market might show. Well, hold on. All it really is talking about is this particular product, but we're now going to make it about some other truth. Therefore, it doesn't even qualify as hearsay before you even get to the exception.
By the way, and I don't have it right in front of me, Hart versus Keenan is a case where it's working, and really is a great exposition of the point that Don and Gary both made, which is this, is the evidence being offered for the truth of the matter or something else, which is often a very subtle distinction. And she does a great job in laying out the rules, helping to define what it is.
So would the better method be to form a witness box who is an expert in the practice of these laws to testify? Or to go back to an expert?
I think if it was a civil case and you were really trying to prove the fair market value or something that you would typically bring in experts, sure, you could bring in an expert. I mean, fair market value can be proven in two ways, and People versus Grant tells us this: expert testimony or circumstantial evidence, or both. But this was just your run-of-the-mill criminal case, and I think during the run-of-the-mill criminal cases, you often, at least ones about theft of dumbbells, you don't have experts brought in to testify. But yes, expert testimony could do it.
Or you could bring in somebody from, Walmart,
Yeah.
who says, yeah, we sell these for $350, and that would be, I think, admissible, and that would be the answer.
Because the expert doesn't have to be a PhD in dumbbell design, because he's someone who's an expert in
Marketing.
the
marketing.
dumbbell.
Yeah.
Sales
PhD
salesperson.
could be philosophy of dumbbells.
That's me.
All right, Don Ramirez.
Okay. So Ramirez does involve actual hearsay. It is all about actual hearsay. And it is in a situation that I think certainly many defense lawyers have been in before, and it's changed the way they do things. This is one of the talc and is there asbestos in the talc cases. Defense verdict on, a defense summary judgment. Okay. A very standard declaration from a PMQ. We never had asbestos in his line, at least since the 1970s. You always use asbestos-free talc. Next slide. And plaintiff Jack says, well, your PMQ, as you did, wasn't there in 1970, it just started in 1994. And the trial court says, well, that's what PMQs do. They go investigate, they look at the company's records, they talk to people, they find out what it was, and that's what they do. So, no problem, we're admitting that evidence, summary judgment granted. Court of Appeal says, not so fast. There's only two kinds of witnesses, expert witnesses and lay witnesses. Only experts can testify based on hearsay. Your PMQ is a lay witness, doesn't get to testify based on hearsay. Here's one of the sort of key takeaways from it. It's just the fact that a PMQ witness might get asked about something in his deposition doesn't make it admissible. When you think about it, well, of course that makes sense. Everything that happens in discovery isn't necessarily admissible. Discovery is supposed to be broad than admissibility. Discovery is supposed to be able to help you get to admissible evidence, but it isn't limited to that. And this is even in some ways worse because of what PMQs do, right? They're supposed to go talk to other people in the company. They're supposed to go clean stuff up out of formerly dusty file rooms and now hard to access ESI and learn things, which means that they don't have personal knowledge, which means that the people they found this out on probably don't have personal knowledge. Same sort of thing. So this is a big deal, but it's not just limited to PMQs, right? It's limited to, it talks about any lay witness who's going to try to testify about something far in the past. The defense in this case argued this is unfair to us because how else are we going to prove what happened in the 1970s or sooner or earlier than that, in one of these long latency period kind of disease cases? The court pointed out, well, that runs both ways. The plaintiffs are going to have a hard time digging up evidence as to what was actually done in this case, or actually happened 40 or 50 years ago. So in this particular case, they had expert witnesses who were going to look at this. There are ways to address this, because again, it's all about hearsay. So how can you back up now? There we go. No, that's it, yeah. Okay. The first is find witnesses with personal knowledge. Gosh, you have to do that for everything else. That shouldn't be such a big deal. There's a hearsay exception for former testimony of witnesses with personal knowledge, which might be, for example, your PMQ who did have personal knowledge, who testified about this at a trial 30 years ago. Maybe you can dig up that transcript. If you have actual business records, this case involved a lot of documents that were found in the corporate file that didn't qualify for business records by a long shot. Emails from people outside the company, stuff like that. And were they in the records of the business? Yes. Does that qualify as a business record? I know everyone listening says, no, that doesn't get you there, but it's a start. Ancient documents, which is anything over 35 years old, which makes me feel, oh, never mind. The hearsay exception on writing affecting an interest in property, which might come up in some cases. I can imagine, for example, if there's an issue about ownership or the condition of real property, well, if that's been transferred in the meantime, you might give that something like that. Or, back to what? Expert opinions. Well, that might be useful if you can, depending on your industry, the right kind of expert. You're unlikely to go out and find someone who's an expert in the history of your company. Right? If you're that, I guess you're already general expert and you're not worried about this or something like that. That's unlikely. But you might find someone who's an expert on that industry who could say, well, in the 1970s, talc manufacturers didn't source their talc from mines that had asbestos. That's one way to do it. Okay, now the next slide is, and I tell this to defense lawyers a fair amount, who say, well, now, it's not fair. So anything that my PMP witness says that is good for me, I can't use because it's hearsay, but anything that's bad, they're going to say is an adopted admission. Two things about that. One is, no, the simple fact that it's an admission that it was said by you doesn't make it an official admission. That takes a lot more. And the second is you can use it affirmatively. And that is when your witness is being deposed, if your witness answers a question that they don't have personal knowledge of, that's what they should say. Well, Mr. Jones, did Avon use source their talc from mines that had asbestos? Answer, I don't know, but I read in blank that blank. That way, you set it up so that you're going to say, this is hearsay, and I'm wanting to know it's hearsay, and I'm broadcasting and putting it on the transcript that it's hearsay. So they won't be able to use it as an admission to come back. And that's the Ramirez versus Avon politics.
There's a couple of extraneous comments that don't directly relate to Ramirez, and that is, in your lexicon of responses to an objection that you hope will be persuasive to the trial court, here's two that I would delete. The judge ruling against me on this is not fair. One of the arguments that Don makes. And how about this one? Judge, I really need this evidence here. So I point that out.
All right, we're going to talk about Doe versus Bright Star. And that case involved a handyman at a care facility had molested one of the patient residents there and fled to Mexico. And of course, there was a civil suit against the owner and operator of the care facility. And this case really is a useful read as a kind of review of some of the steps that you go through in dealing with layers of hearsay. But I'll start just by saying that it's a recurring theme for me with respect to courts not always agreeing about how the evidence code works, because in this particular case, the police report was excluded, and with the police report being excluded, so was some key witness testimony in the police report that the plaintiff wanted to rely on to defeat summary judgment. And that being excluded, the defense obtained summary judgment and the plaintiff appealed. And so the issue was various witness statements that were referenced in the police report and the police report itself. And I'm kind of starting in reverse, but I'll just talk about the police report itself for a second. And in this case, the Court of Appeal found that the police report fell under the official records exception, which, as you probably know, the writing was made by, within the scope of duty of a public employee. The writing was made at or near the time of the act, condition, or event, and C, sources of information and method and time of preparation were such as to indicate its trustworthiness. Now, one would presume, whether you're before a court that has ruled that they can be excluded, or whether you're aware of precedents as they can come in, you're going to run into this problem because some courts of appeal have ruled they're not official records, and some have. And I think one could always argue that, put the police officer up there and talk about the timeliness, talk about the duty, talk about how quickly it was done, and so on, so that you can make a record that it would qualify as an official records exception. But anyway, courts go both ways, and some recent appellate decisions say no, it's not an official records exception, a police report. And in this case, the court said yes, it is. And I can only presume that it was based not just on generalizations about police reports, but hopefully about actual foundation that was laid in the case with respect to the police report. So once again, we're talking about the evidence code, and we like to turn to the experts and see what they have to say, and they don't always have the same answer, and sometimes they disagree. And so I guess we should get used to that and keep struggling with evidence. Now, the individual statements in the police report, we all know that it's not just, I got the police report in, or I got it recognized as official records, I'm good. I'll just have the jury take that back there with them. But no, you have hearsay within the document that you have to adhere to, and this case is a good reminder of just walking through and seeing different ways that this was reversed on appeal. And one of the statements was by several of the employees of the defendants had said to the police officer that the handyman was frequently there during different times when he wasn't on duty. He was basically hanging around the facility a lot. And the trial court had excluded that as being offered for the truth to pinpoint him at a particular time in a particular location in the facility. And what the Court of Appeal said here is no, these statements are not offered to explain where the defendant was at any given time. They're offered to explain that he was frequently there, and that would put a reasonable owner or manager of the facility on notice to such frequency and such times when he's not working that he's hanging around. So
you say it's not for the
This is
truth.
trouble.
How can it be noticed of something unless we're assuming that what it's noticed of is true? If we're getting police reports of lies, and isn't that why we have a hearsay rule?
Well, we have cross-examination, right? We have cross-examination. So if this is going to come in, that's not the end of the case, right? Presumably there's going to be a chance to poke holes in the police report creator, which is the police officer. We're going to have a chance to poke holes in that testimony if one of these witnesses is actually there. And so I think that's the way you counterbalance the fact that it's not offered for the truth. It's not disabling. The issue here is there an issue of fact? So we're not at trial, we're talking about is there an issue of fact? We don't weigh the evidence, right? We'll do that at trial, we'll cross-examine at trial. But should summary judgment have been granted? And I know Don's a defense lawyer and he doesn't want this evidence to come in, and I'm just a messenger here. And I'm saying that it wasn't offered for the truth that he was there on any particular occasion, and it certainly wasn't offered, I'll be clear about that, to prove that he was there on the night or the moment in question. That wasn't the issue. And then the other ones are a little bit easier. For example, one of the witnesses told the police officer that he frequently referred, the perpetrator had frequently, the patient had frequently, whenever she saw the handyman, referred to him as daddy. And that evidence had been excluded. It was offered to prove familiarity. It was offered to prove some kind of amorphous intimacy or general intimacy. And it's certainly, I think we can all agree, it probably wasn't offered to prove that the handyman was her father. Okay. And certainly the acts of the perpetrator were inconsistent with him being the father, right? But it comes in on appeal. It's excluded by the trial judge, and it comes in. But I guess what I'll say about this case is that Don said earlier that we can always think of some purpose, some for the truth purpose of testimony, or that we ought to be able to. But to me, generally, and again, Mark mentioned a headache from reading People versus Portillo, right? I get headaches from hearsay all the time, no matter what case I'm reading, and maybe that's just me. But it just shows you that you can peel the hearsay onion in numerous ways, and you ought to be thinking of 2 or 3 ways to get that evidence in. And the bottom line here is, the Court of Appeal said, for purposes of summary judgment, not for trial, for purposes of summary judgment, where we just look to see if there are disputed facts, there were sufficient facts that ultimately all together could have established knowledge or constructive knowledge on the part of the owner of the facility, and summary judgment should not have been granted.
So the title of our talk today is Struggling with Evidence, and a couple of times when Gary just discussed, he talked about struggling with evidence, and I've often said that when sort of talking about lawyers and their understanding of evidence, and same with judges and your understanding of evidence, you can describe, you can break the group down into 2 different groups. Those lawyers who struggle with evidence, and those lawyers who don't get it at all. And your goal should be to struggle, one of those who struggles with evidence. And I mean that in all sincerity. If you understand it completely and you don't need to struggle with it anymore, my advice would be, now's the time to retire. Okay.
It's your turn, Mark.
Yeah, and I kind of want to, I know we were given the green light to go farther, but I'm not comfortable with that. Farther than 11:30, because as long as we don't get it started. So I want to talk about, I want to skip a little bit. And, okay, can we go back to the last one? Okay, we're going to talk about these 2 cases, Bowser and Bravo. Bowser has a great discussion, next slide, of the section for authorized admissions. It's a great discussion. It is, in my view, a very liberal interpretation of the exception for authorized admissions. And one valuable thing it does is it discusses numerous, by the way, classic authorized admissions are businesses, companies. Corporations, only speak through their officers, other persons. But the same is true of even small businesses. It's not only the owner who can talk about stuff. Sometimes a person of a particular set of responsibilities also has the ability to talk about those responsibilities. Anyway, in the Bowser case, there's a great deal of discussion on authorized admissions, looks at numerous emails sent between corporate officers dealing with the issue in the case, which actually is the same issue as the derogatory case, as I mentioned in a moment. And you should read that whenever you've got an authorized commission issuing a case, whichever side you're on. Again, I said it's a very liberal interpretation of that rule, but they hit a bunch of emails, reject a bunch of emails, and just the sheer number will maybe give you an insight into your particular email or whatever it is, your particular communication, and whether that should fit on the list. So let's go to the next slide. I'm not going to talk any more about authorized commissions. Next slide. Okay, next slide. Now, I am going to talk about the hearsay exception for former testimony. And that involves a discussion of evidence code sections 1290 and 1291. Have any of you ever been in a situation, criminal case, maybe you have only one criminal person here, where the prosecution wants to introduce at the felony trial testimony from the preliminary examination? And how about in civil case? Party wishes to introduce a deposition, either taken in the same case or in a different case. You've seen that, right? What's the rule? What's the evidence code section, by the way, that deals with introducing depositions from the same case? Anybody know the answer to that? The answer to that is there is no evidence code section that deals with that. It's the Code of Civil Procedure. Discusses the rules if the depo is from the same case. That's CCP 2016 through 2036. But depositions in different cases, that is discussed in the evidence code. So, 1290 discusses when these rules apply. 1291 discusses what the rules of admissibility are for former testimony. Next slide. 1290 says that these rules apply when the former testimony is given under oath in another action or in a former hearing or trial of the same action. Example of former testimony in the same case, criminal case example, retrial. I suppose you have the same case too. You have a retrial. Jury hangs up, or the case gets reversed. So, and that would be an example of the same case. How about a former hearing in that's okay? Excuse me. That is a retrial. So that's an example of a trial in the same case. A former hearing in the same case could, for example, be a family law case, where you have a hearing on interim support, interim custody, and then subsequently there's the trial on support and custody, and you're allowed, 1290 allows, in the circumstances set out in 1291, the former testimony to come in. So let's talk about depositions in a different case. This has been a hot issue for a few years. So in both Barometer and Bowser, same procedural background. There was multi-district litigation, class action against Ford for defects in its diesel engines and its trucks. And as often happens, that case settled, there were opt-outs from the case. Two of the opt-outs were Bowser and Barometer, who brought cases in California courts. And at some point, and we'll talk about Barometer first, Broderick wanted to introduce evidence from the witnesses who had been deposed in the multi-district litigation and who were Ford employees. And they had summoned the witnesses. Ford defended the deposition. All right, next slide. Under 1291A2, you can introduce testimony against a party who was a party in the prior proceeding, right? Ford is being sued by Broderick. Ford was the party in the multi-district different litigation. You can do that if the declarant is unavailable. It's offered against one who was a party in the former proceeding and had the right and opportunity in that former proceeding to cross-examine the declarant. That was certainly Ford in the earlier deposition with, and this is the key, similar interest and motive as Ford has in this case. By the way, if Ford had introduced the evidence in the formal proceeding, let's say it was an earlier trial in multi-district litigation, then you can introduce it against Ford easily in the subsequent case. But where Ford doesn't introduce it, then right and opportunity to cross-examine, and most significantly, similar interest and motive. Let's go to the next slide. This A2 articulates a general rule against admitting prior testimony from a typical discovery deposition, right? Almost all depositions are discovery depositions. And those are generally, not always, going to be excluded from coming in because they find the interest and motive at the deposition is not the same as the interest and motive at trial. And that general rule, according to the Supreme Court, it rests on two different legs. First, at the deposition, Ford doesn't really have an interest or wants to avoid premature disclosure of what its defense is going to be, or even bring out facts that weren't brought out by the plaintiff in the deposition. Second, the deposition occurs before the defendant party often has full disclosure in the case as to what the plaintiff is seeking to prove. So that justifies general rule, not categorical bar, of no discovery depositions at the subsequent trial. Next slide. In Broderick, the Supreme Court distinguished depositions taken to preserve testimony, right? In that situation, the defending party does have almost exactly the same interest and motive at the deposition as they would have at trial. And what they said in Broderick was that the burden of proof is on the deponent. It's on the proponent. The burden of proof is on the party, in this case it would have been Broderick, to show that it is that the former deposition was designed to preserve testimony as opposed to new discovery deposition. So if the trial court's left not knowing, then the depo doesn't come in. And then Broderick set out a multi-factor test, 8 different factors that the trial court should take into consideration in deciding whether it's a mere discovery deposition or a robust deposition to preserve testimony, allowing it to come into the trial. I'm not going to get into what all of those factors are. Yes? You need to use your outdoor voice.
Oh, sorry. Would a statement made by counsel on either side of the deponent in the original deposition that the deponent is 87 and this deposition is being done to preserve their testimony?
Oh, absolutely. Factor one, the parties understood at the beginning of the deposition, early in the deposition, that it was going to be used to preserve testimony. Number two, factor number two, the parties reached an agreement at some point that it would be used as a deposition to preserve testimony. So, answer your question, definitely yes. The other factors are interesting. Let me have, so in Broadern, they said it was a mere discovery deposition. Maybe I can't remember, they may have remanded for the trial court to figure it out again. Now that they knew the 9 factors, 8 factors. And those factors then by the trial court had to be either orally or preferably in writing disclosed by the trial court on the record. I mean, they treated this as a very, very big issue that needed to be resolved by trial courts. They spent this case very formally. I'll only say next slide is Bowser. And Bowser came up from the same procedural context of an opt-out from that multi-district class action. Bowser came up subsequent to Broadern, and in Bowser, the court said, this is we find that this was a depot to preserve testimony. And look at some of the factors that are listed there. They said the opt-out cases were foreseeable, the settlement of the opt-out cases at the time the depot and the multi-district was. It was videotaped, that was a factor. On the other hand, Ford asked no questions at the depot. That factor pointed in a different direction. Ultimately, Bowser said, and Bowser's the only published case I'm aware of that applied to the Broadern factors. So those two cases, absolutely critical when dealing with that question, which I think is a question that's been bothering the trial courts for some years.
I think based on when we started, we could probably do about 4 more minutes. Do you want to just briefly hit on the next case?
Sure. Doe versus software one, I can do that in maybe even less than a minute. So it's an employment case. The employee says, they called me a bitch. The defense says, that's hearsay, excluded. No, it isn't. We all know that. Why isn't it hearsay? Because she wasn't admitting it for the truth of, I am a bitch. She was seeking to admit it for proof that she had a hostile work environment. Folks who managed to get that excluded the first time through, awesome lawyers, but they must have been because I can't believe it. It seemed like a real easy case to me. And now you know that that bitch is not hearsay involved with anyone in your opponent.
You know, it's interesting because that's probably the easy route. Now, I've read cases over the years that describe that coming in for another reason as an operative fact or a legal act or so on, right? And not even just that it wasn't offered for the truth. So here we go again. Well, listen, how about if we just take questions for a couple minutes, and if there aren't any, we'll adjourn. And there being none, we'll adjourn.